Hello everyone. In this topic today, we are talking about the constitutional issues in cyberspace. So we will be discussing certain constitutional rights and how these rights they are available when we talk about the cyberspace. So we will talk about the privacy issue in cyberspace. We will also talk about freedom of speech and expression in the cyberspace. Then we will be taking some of the case laws which are decided by the Supreme Court of India and how judiciary that has interpreted the constitutional rights in the cyberspace. We will also be discussing some of the important provisions relating to these issues, the constitutional issues under the IT Act 2000. Then we will be finally concluding the topic. So coming to the introduction first. So talking about the world of internet. Now the computer networks and the telecommunication technology and the other digital technologies that has given birth to a new virtual environment which we all know as the cyberspace. And this cyberspace in the present time, it has become a platform for a galaxy of human activities over the internet. And the law which is associated with the activities of the citizens, which regulates the activity of the people on the internet, that is largely contained in the Information Technology Act 2000. But when we talk about the constitutional rights, and in particular the freedom of speech and expression and the right of life and personal liberty, they are still regulated by the Constitution of India under 21, Article 21 and Article 19 of the Constitution of India. Now, when we talk about the privacy issue in the online world or whether it is the offline world, there is no distinction as such when we talk about the provisions which are there in India. So if any kind of crime is there relating to the privacy, whether that happens in the online world or it happens in the offline world, all such kinds of crimes, they are to be dealt under the same provisions or within the same umbrella. Now there is no separate provision for dealing with the online privacy. So the same provisions are there, whether that is the offline privacy or that is the online privacy. Now talking about India, India is the host of the biggest platform when we talk about the data processing. And it is also a fact that though we are saying that India is having the biggest platform of data outsourcing, but the other fact is this, that the crimes against the privacy of the citizens, that is also on the higher side in India. Many countries in the world, they are having their own separate law in terms of data protection, but in India, till date, till the start of the 2020, we are not having the separate law which deals with the privacy of the data of the individuals or the citizens. Now the courts in India, that has interpreted the right of privacy as well as the freedom of speech and expression within the existing fundamental rights of the citizens under the Constitution of India. Right to privacy that has been interpreted by the courts uh, as an implicit right under Article 21 of the Constitution, as well as Article 19. It also gives the rights to the citizens, the freedom of speech and expression in the online world as well. Beside that, the Indian Contract Act as well as the Information Technology Act, they governs certain provisions are there which deals with the uh, privacy issue and the freedom of speech and expression also in the online world. Now, talking about the freedom of speech and expression, so as we have discussed that these are still regulated by the Constitution. Under Article 19(1)(a), it gives the freedom of speech and expression to the citizens, although these are not the absolute rights, and certain limitations that can also be imposed by the states on certain grounds which are mentioned under Article 19(2) of the Constitution of India. Although this right, this freedom of speech and expression that can be expressed, that can be exercised by the citizens in terms of uh, words of mouth, or whether that is in the form of certain pictures, printing, writing, or any other mode. So this can be exercised by the individuals in any like modes. Now, freedom of speech and expression, that basically means the power or the right of the individuals or the citizens to speak something, and without any restraint, undue restraint, or any legal penalty, and unhindered flow of information or the flow of words within in an open forum. It is considered to be one of the essential democratic right in every democratic society. Talking about the freedom of speech and expression in the cyber world or in the internet world. Now, with the introduction of the internet, it has given new expansion to the right of or the freedom of speech and expression. And this is the platform in the modern time which is used, which is mostly used by the people, and which is the most popular form, most popular way of expressing the individual's uh, individual freedom of speech and expression on the internet world. However, again, this is again not unregulated, but that is regulated by law, that there may be certain kinds of restrictions which can be imposed on the rights of the citizens as well when we talk about freedom of speech and expression in the cyberspace as well. Moving forward, we are now discussing some of the case laws which are decided by the Supreme Court of India, where the court has interpreted the existing rights, these rights, and within the purview of the fundamental rights of the Constitution of India. And a very important case in this regard is Justice K.S. Puttaswamy versus Union of India. Now, this case was filed before the Supreme Court of India under Article 32 of the Constitution. And in this case, the question before the Supreme Court was that whether the right to privacy was guaranteed as an independent fundamental right under the Constitution of India. Now, in this case, the challenge to the government Aadhaar scheme was there, that the government that has provided that to exercise, to have the access of the government schemes and services. Now, it is essential that the Aadhaar must be attached to those to those schemes for the access of those schemes. And the Supreme Court in this case held that this scheme is violative of the right to privacy. However, in this case, the Attorney General from the side of Government of India, now he took the plea that the right of privacy that is not expressly covered under the provisions of Article 21 of the Constitution of India, and as decided by the Supreme Court in its earlier judgments in MP Sharma versus Satish Chandra, as well as Kharak Singh versus State of Uttar Pradesh, a very restrictive meaning was assigned by the Supreme Court in Kharak Singh versus Union of India, as far as the uh, right to privacy is concerned or the personal liberty right was concerned. So taking this view into consideration, the court overruled its earlier judgments, which was given in MP Sharma as well as in Khadak Singh versus State of Uttar Pradesh. And a 9-judge bench of the Supreme Court, by an unanimous opinion, recognized that the Constitution of India, it guarantees the right to privacy as an intrinsic part of the fundamental rights of the citizens under Article 21 of the Constitution. So, in very clear words, the Supreme Court, said this, that the right to privacy, it is an inseparable right which is there recognized under Article 21 of the Constitution. While delivering the judgment in this case, Justice Chandrachud, while he was speaking on behalf of himself and the then Chief Justice, Justice Kehar, Justice Agarwal, and Justice Nazir, observed that privacy was not surrendered entirely when an individual is in the public sphere. The court further held that the right to privacy includes the negative right against the state interference, as well as the state has the positive right to protect the interest or the rights of the citizens as well. The court further in this case also held that it is necessary that in India, the data protection law that must be incorporated. The second important case in this regard is Shreya Singhal versus Union of India. This case was again related to the fundamental rights of speech and expression. And in this case, again, it was in the form of a writ petition which was filed before the Supreme Court under Article 32 of the Constitution of India. And here again, certain provisions of the IT Act 2000 that was challenged as violative of the Constitution of India. Now, while delivering the judgment in this case, the court struck down the Section 66A of IT Act 2000. This particular section, it provides police power to arrest the person for posting offensive content online and provides a 3-year jail term to the persons who are arrested thereby. The court said that the provisions, these provisions which are there under Section 66A, it clearly affects the fundamental right to freedom of speech and expression, which is enshrined under the Constitution of India. And the terms, the words which were used in this section, like annoying, inconvenient, and grossly offensive, the court said that these words, they are vague in itself, and it is difficult for the law enforcement agencies and the offender to know the ingredients of the offense. So on this basis, the court ultimately struck down Section 66A as violative of Article 19 and Article 21 of the Constitution. Another important case where the Supreme Court laid down certain tests for determining the reasonableness of the restrictions which are imposed on the fundamental rights of right of speech, freedom of speech and expression, that was laid down in VG Rao versus State of Madras. And here the court said that there will be certain essential conditions for determining the reasonableness. First, that the nature of the right purports to have been infringed, that is to be seen. Secondly, the object of the restriction imposed, what is the object, that is to be seen. Third one, the extent and urgency of the evil that is sought to be remedied. The court will also take that thing into consideration. And the common condition at all time. So overall condition will be seen for the purpose of determining the reasonableness of the limitations which are to be sought by the state or its agencies. Now we come to the provisions relating to the constitutional rights and under the IT Act. And the first section which we are taking here, that is section 72A. And this section, it provides punishment for those persons if like intermediaries is there, any third person is there, who are uh, containing the information in their relating to the individuals or the persons in their computer. And if due to the negligence on the part of this third party or the intermediary, if any kind of disclosure of that personal information belonging to the individuals that is done without the consent of the concerned person, now in that case this section provides that the intermediary or the third person that can be punished with the imprisonment which may extend to 3 years, and such person shall also be liable to a fine which may extend to rupees 5 lakh, or both these punishment can be awarded to such person. Next section here is section 43A of the Information Technology Amendment Act 2008. Now this again, it expressly provides that where a body corporate is there which is possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns or operates, and if they are negligent in implementing and maintaining reasonable security practices, and due to that certain wrongful loss or wrongful gain happens to any person, then such body corporate shall be liable to provide compensation to the person who is affected thereby in the form of damages. Next important section is section 69, and it provides for the power of the central government or its agencies to issue directions for blocking public access of any information through any computer resource. So this particular section, it gives the power to the government that it can deny public access to any information through any device. By this rule, the government can interfere with the privacy of data in certain conditions. Now, there are certain grounds like defense of India, security of the state, friendly relation with the foreign states, or incitement to an offense. So on these grounds, the government can deny the public access to any information. It may, the government or its agency, it may by order, government may by order direct any agency of the government to intercept, to monitor, or to decrypt any information which is stored in any computer resource. So this rule, it gives the power to the government to interfere or to monitor or to decrypt any data or any information that is personal in nature, and which is there in the computer or any device which belongs to an individual. Now, talking at last about the concluding remarks. Now, the free speech, now in cyberspace in particular, it is not just a new drink, merely a new drink in the old bottle. Free speech jurisprudence, it not only to be applied in cyberspace, but also to be carefully modified, as we have talked about earlier, that there are certain new challenges with which uh, the cyber related activities that happens on the internet, though, so the people, they are also faced to certain new challenges. So the privacy related issues and the issues which are related to freedom of speech and expressions, they are also to be handled with care by the government in this regard. So it is very much necessary that for the protection of the privacy of the individuals as well as the freedom of speech and expression, that certain new legislation that is to be passed by the parliament in this regard. So that is it in this lecture. Thank you.